You sit down and type out a statement to the press concerning one of the cases you're litigating on behalf of a client. As you think about the statement, you look through the complaint and some other filings to pull some allegations that you want to include in the statement. Is that a good idea? In this video, I'll tell you why it might not be. I'm Wayne Pollock, and you're watching Copo Talk. In this episode, defamation. We know as attorneys that most of the things that we say in court, either in our filings or during court proceedings, cannot be the basis for a defamation claim against us. Why? Because the litigation privilege is a defense to defamation. And that privilege says that attorneys will not be held liable for defamation for the contents of their court filings when those court filings and other written materials arise naturally within the course of a court proceeding and are relevant to a court proceeding. There's bad case law out there that says attorneys do not get the litigation privilege protections when they talk publicly about their cases outside of court. For example, there's bad case law that says attorneys lose the protection of the litigation privilege when they send copies of complaints, even court-stamped as filed copies of complaints, to the press. In addition, attorneys and their clients could be liable for defamation when they're making public statements to the press concerning the allegations in a complaint or in a lawsuit. So, what's that mean? When you are drafting as an attorney, you're drafting public statements about the cases you're involved in. You want to stay away from asserting that the allegations are facts. You want to make sure that you're saying the complaint alleges or as we allege. That helps protect you, that should help protect you from any claims of defamation. In addition, rhetorical hyperbole, statements that have no way to be confirmed and that are clearly opinion, those are going to be a safe harbor for you as well. So for example, to say that someone simultaneously had their head both in the clouds and buried in the sand is the kind of hyperbole that you can engage in. Attorneys often don't realize that when they take their allegations out of the framework of a court filing and put it into a public statement to the press or in an interview to the press, they're losing the protection of litigation privilege and can open themselves up for defamation, claims defamation by the opposing side. If you like this video, please subscribe to our YouTube channel. Check out our social media feeds, copostrategies.com and copocetic.com as our blog. Till next time, thanks for watching.